In early 2026, we gathered a panel of leading experts in the field of shareholder disputes at the office of Laytons ETL. The panel comprised Barrister Paul Mitchell KC from 4 New Square, forensic accountant Daniel Djanogly and tax expert Jamie Muirhead from Wilder Coe, and myself, Geraint Thomas, the head of disputes at Laytons ETL, with my litigation partner and regulatory expert Ben Thorogood.
Episode 6. Professional Duties.
So in the context of experts, when an expert is appointed, his duties are obviously to the court, and it is actually surprisingly easy for an expert to become effectively compromised by the way that he relates to his instructing clients. So, I mean, in the example we've been talking about with, for example, Geraint picking up the phone to you on day one, I think it would be quite difficult after, say, 2 years of giving advice to Geraint about how to ask the right questions and how to shape the valuation for you ever to be the independent expert instructed in that case, because obviously you would have been taking a role to advance the interests of the client. So that's kind of an easy one. But it's also the case that during the valuation exercise, quite often the expert might have questions, and you might make the mistake of allowing the expert to deal directly with the lay client without lawyers being present. And what happens then, even though it's all done in good faith and it all seems to make sense, is you're giving one expert access to facts and information which is not precisely the same as the access that the other side's expert has got. As that imbalance begins to develop, then what tends to happen, or what can happen, is that people try to cover up this loss of impartiality on the part of the expert and just sort of bury it, and that's when the trouble really begins. So, I mean, one of the things that the lawyers do in this sort of situation is try to keep complete visibility on how those relationships, which are, so important, but which are kind of taking place, people just don't really appreciate often the impact of the communications they're having.
It's very, very important. I would say it's a very important point. That's my first point. The second point is is that I think we need to qualify your reference to the expert's duty to the court in this way, and that is that it's not the sole duty of the expert. The expert retains a secondary duty to the client.
Certainly.
The third point is that when you recognise your duties to the court and then the secondary duty to the client, you've got your own duty effectively. It's not your duty is to help the court, and it's how I as experts with an independent, objective stance feel I can best do that. And that extends into how I communicate with those instructing me.
Right.
That I will give my view, this is a perspective view, my point of view, or my view on what it is I need. I know I've got a primary duty to the court, I've got a secondary duty to the authority, I've got my duty to deliver the result that I think is right with all of those duties. So I will communicate with my instructing solicitors in that arm's length, cold arm's length way, and there may be a tension between us, and that may be seen in the correspondence, because I want what I need to discharge my remit, and I accept that you've got the litigation team has its job to do, and somehow we'll get to the end.
That's healthy, though, isn't it?
That's the point of view. Yes,
It's not a difficulty.
It doesn't win clients, but it's how we have to do the business.
It's not a difficulty that the experts, whether it's joint or otherwise, it's not a challenge that only the experts face, because as the lawyers, we impose similar duties to the court, to our own clients, and trying to navigate those sometimes competing professional duties can be a challenge, particularly if you are in the arena of claims of fraud, where it may be the case that one of the parties or more than one of the parties has committed some fraudulent act, and what we can't do is be hired guns that pursue any and all claims, and we owe duties to interrogate our own client's case, the evidence that supports it, and for the most part that's a good thing, because you want to understand what if any gremlins lurk, and you only want to be advancing a case that's sufficiently robust that it will withstand scrutiny, but there can be those tensions.
Yeah, I mean, in short, neither of us are hired guns. We have our own professional duties. This often for us arises when we have, as you say, a fraud claim, and our client is saying to us, it's as plain as a pikestaff that they've been up to no good, talking about their counterparty. And you start to interrogate this, and it's never, or very rarely, as clear as they want you to believe, or as the case that they want you to advance for them. And then this really coalesces at the time when we're asked to put down the allegations in a pleading, in a statement of claim, in a petition, whatever it may be, and learned counsel has to put their name to this and to make a decision. Do we have enough evidence here properly to maintain an allegation of dishonesty? And they're quite hard decisions sometimes.
I think I think they're very good control mechanisms, actually, because obviously if you have a conservative set of rules about making wild allegations, or allegations of behaviour which is outside the norm, then you are going to make those allegations in appropriate circumstances, and you won't end up weaponising the law to accuse people of dishonesty left, right and centre, a very popular thing in some quarters these days, especially overseas. But Geraint's point here, I think we're all talking at the moment, aren't we, about the kind of value of us as professionals and our own regulatory obligations and our own sort of training and integrity in bringing these claims successfully to landing, and looking at the ways in which claims could be derailed effectively by human error. I don't think anyone's kind of going to depart from there, and every so often you come across a counterparty where you're a bit surprised by the choices they make, but you never know the full story. But the fact is, these are very difficult. There are so many moving parts, aren't there? And because subjective judgment is playing a big role, especially on a client's part, our collective roles of bringing, to the extent one can, objective judgment to resolving the problem, is very helpful but complex. I think this conversation is illustrating quite well, how talking about the same subject, you can get 4 or 5 really quite different views, all saying something useful.
And whilst you can't and shouldn't weaponise these types of consideration, professional obligations and things, but that there is something to be made of if you identify something that appears to you to be an issue, prompting your counterpart to properly interrogate it with their own client. Because if either it's a genuine issue that may expose risk, or it's something that they can give an answer to, but so we can't sort of use the professional obligations as a sort of litigation strategy, but using them as context for saying we see this issue with your case, and interrogating it in a proper way. You can make good use of this structure that's...
And in an expert witness assignment, there is an advisory component to it.
No.
which is without prejudice wrapper.
Yeah. Yeah, you're talking about the relationship with the
With the
instructing
yeah.
client. Yes, absolutely. Yeah.
This may turn out this way, it may turn out that way. I can't tell you at the moment which way it might go.
But these are my objective views.
Yeah. I mean, I've seen that on a number of occasions from various different experts. And particularly, I see it where they are nervous about a perceived point of weakness in the case that they are asked to give evidence in relation to, because they want to give the instructing party an opportunity to consider that aspect of the case, to see what other evidence might be available to support it, or if there isn't other evidence available to support it, to enable them to think about what the implications of that.
And this
may
is the expectations managing expectations thing about ultimately you're going to get an expert witness report which will say what the expert witness thinks.
Yes.
And that may cover the different possibilities or different scenarios that identified earlier in the advisory element.
I mean, it is. I mean, for me, instructing an expert to produce a report involves a loss of control. Yeah, it does. Because the expert may say things in their report consistent with their duty to the court that my client may not agree with. They may then have a discussion with their counterparty expert, and they may reach agreement on points in the case which may involve concessions in respect of my client's case. And that is, consistent with their duties as expert. They are.
They're not committing your client. They're not committing the party at that point to anything. It's just the agreement in the limited area.
And there are
And then they make fair concessions in the witness box. And it is quite. I mean, I would be a fool to think that a judge, after hearing and reading the evidence of an eminent expert, is going to reach a view that is more consistent with mine, if it differs from my own experts, and less consistent with the experts. Of course they're going to take the advice that they get from the people that are experts in that field. So that loss of control is important, and it's particularly important where you have a single joint expert, because
you don't have control. I mean,
you have no control.
If you had some control, you don't have.
You're conceding control to them almost in the same way that you concede it to a judge in court.
But there are mechanisms for, if not regaining a degree of control, just so that mitigating the extent of the loss of control. Because if there is a particular concession that's made, that you can ask written questions, or if the evidence is given live, that there are questions that can be asked to sort of try to put within the context you want it. That's that bit of session.